is a friend of the Institute, and you're on the faculty at the University of Toronto, and he's a neurologist. So, Paul.
Great, thanks. It's a great pleasure to be between the two speakers. Ian and Will are two of the most formative people in whatever involvement I've had in the pro-life movement. And if they ever want a second career, aside from academia and scholarship and family care, they should try sales, because they've been very, very persuasive and inspiring to me, both of them, and getting me more involved than I probably should have been. But they're an ongoing inspiration. Now, Will and I, Will Johnston, our speaker tonight, go back far enough that I don't care to remember in counting the years. But I know him well enough to chuckle when asked for a biography. He sent 3 short sentences. If I could paraphrase, one was he's a full-service family physician in Vancouver. He's an assistant professor of family medicine at the University of British Columbia and chair of the Euthanasia Prevention Coalition. And that's all very true, but each one of those sentences could be the subtitle of a chapter under which there would be numerous accomplishments that he's far too modest to allude to. And it's ironic that he's perceptive enough, even in that first sentence, that he's a full-service family physician, because of course, besides his office practice, he delivers babies, visits nursing homes, and he's still doing house calls. I'm not perjuring myself, so he is, but he may not be able to use that title of full-service physician within a year or two, because he would choose not to kill any of his patients or refer them for abortion, and that, under the new definition, you mean he's not a full-service physician. That is exactly the crux of the issue. From our point of view, the profession of medicine, and you as the potentially very vulnerable patients, Will is a tremendous person. He's honest, hardworking, and always an interesting speaker. He speaks from knowledge, from experience, and from the heart. And I always enjoy listening to him. Will Johnston, welcome.
Thank you very much for those kind words, Paul and Ian, for your very, very succinct summary of where we're at. I'm going to try not to wander on for too long before asking for some questions from the audience. I really want to know where people are at and their understanding of this catastrophe that has happened to us. And it really is a catastrophe. This is something that is going to change Canada, and not for the better, for at least the next several decades, I would predict. I think this is going to be very difficult for us to get rid of. I'm going to use a very poor speech technique here by reading and then commenting on what I'm reading, because I think it'll work. I originally had written, as I was starting to write this talk, I wrote, "A Mistake Made in Fear," as the title, but then I thought, no, I really want to go back to the idea that whole societies get swept up in stupidity from time to time, and many of you will be familiar with I think it's 1831 book, Extraordinary Popular Delusions and the Madness of Crowds. Anyone remember the author? But anyway, this talked about the South Sea scandal, and the bubble, and the Louisiana land bubble, and the tulip craze in Holland, and you know, the tulip craze was where people bid the price of tulip bulbs up to the point where people were going bankrupt buying tulip bulbs. And you think, how does a whole society get swept up into this sort of craziness? And of course, there are always many, many reasons, but you have the great privilege of living at a time where you have a ringside seat at something sort of like the tulip craze, only it's a lot more deadly than that. And it is this conviction that the solution to our problems when in difficulty, not necessarily anything to do with dying, but when in difficulty, is death. And I think people will scratch their heads at some point in the future when this blows over and we hopefully manage to recover from it, and just sort of ask, what were they thinking? But let me hopefully not bore you too much. I'm going to read a little bit. As everybody in this audience already knows, a few months ago, Canada's Supreme Court rejected 2 laws which had formerly been created and affirmed by the democratic parliaments of the United Kingdom and Canada over many, many years. These are very, very old laws. One law makes it wrong to encourage suicide. The other makes it wrong to agree to be murdered. There is this other law that people aren't aware of, which is Section 14 of the Criminal Code. It makes it a crime to actually agree to have someone murder you. And you can understand the rationale for that have been put in place for very good reasons over the years, and obviously has been a problem at some point or would not have been put into place. I will leave it to legal scholars to dissect this malfunction of our highest court. The ruling was unanimous, which is to say that 9 smart Canadian judges all malfunctioned as a team. So I am curious to eventually learn what was going on behind the scenes, and half fearful that the answer is not much, other than a group failure to pay more attention to Parliament than to the polls, to the crowd and to the Constitution. One of the frustrations of listening to the argument was to endure repeated assertions, as Professor Gentles just mentioned, that the judges were stepping in only to make decisions that Parliament was shirking, when in truth Parliament has decided against legal-assisted suicide repeatedly for the past 20 years. While picturing the image of 9 judges robed in black while ignoring Parliament, the playground equivalent of plugging both ears and yelling, "Na na 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 na," comes to mind. I can't imagine, in fact, a lower point that our Supreme Court could sink to than the series of shenanigans that led to this ruling. To their evident disdain for the messiness of the parliamentary process, the judges added a willful and whimsical interpretation of part of our Charter of Rights and Freedoms. And Ian touched on this. I want to just enlarge on this a little bit because it's so hard to wrap your mind around it. It bears repeating. Section 7 was written and intended to guarantee our right to, and this is it literally, life, liberty, and security of the person. Life, liberty, and security of the person. That was to protect us from abuses of government power which could kill us or impose physical intrusions upon us. In other words, it was written to enshrine our right to be left alone and to not be interfered with. Instead, the judges decided that if you felt spooked into killing yourself sooner because no doctor would be available later, you had been deprived of some span of life, not by your own act of self-destruction, that is, by interfering with yourself, but by the law failing to soothe you by promising a doctor would help later. If this soothing really worked, we might expect it to reduce the number of suicides, and in fact, the promoters of assisted suicide and euthanasia have projected and promised and claimed that they were going to reduce suicides by soothing, by reassuring the potentially suicidal person in a difficult life situation, that they need not commit suicide now, that a state-endorsed and a state-arranged suicide would be available for them later. Why couldn't they just hold on? Sadly, the latest research on this topic, published October 10th of this year, in the Southern Medical Association Journal concludes, and I quote, legalizing physician-assisted suicide has been associated with an increased rate of total suicides relative to other states. They're talking about the states, the American states, which allow this practice. An increased rate of total suicides relative to other states, and no decrease in non-assisted suicides. This, in fact, is a very cautious statement. In Oregon, which has had the use of an assisted suicide law since 1994, their suicide rate has actually risen at a faster rate than the national average. And we have to ask, of course, there's no direct proof that their promotion of assisted suicide as a solution to difficult situations in life has led to a reduction of a lowering of the threshold of social inhibition against suicide. But we know that such a lowering of the threshold actually has been demonstrated to happen. For instance, when Robert Latimer, after he murdered his daughter Tracy, when he was in court, and he was in and out of court, every time he was in court and it showed up in the news, it has been documented that there was an increase in incidence of the killing of children in care. So children with various disabilities who were in care. And this very sad example of copycat murder was documented by Dick Sobsey at the University of Lethbridge. Now, we've also seen, and this is beyond controversy, that the reporting of suicides and I was going to say lionizing, but the admiring, the glamorizing of a person who is suicidal, such as we saw with the Brittany Maynard video, has led to an increase in suicides. And that was sort of academic to me. I knew that press councils the world over have rules as to how you report a suicide. And it's considered irresponsible when reporting that a suicide has happened to write admiringly of the person who's died from suicide, to give details of how they committed suicide. And there are other points that if any of you here are journalists, you would have heard of. So well is it accepted that this phenomenon of copycat suicide or suicide contagion can cost lives, that press councils have regulations about it. The next piece of chicanery, besides this bizarre business of using the fact that you were going to shorten your own life, meant that the law had violated your life. In other words, the misuse of Section 7, which was to protect you against the intrusions of government, was never written to address the issue of self-destruction being used to help to throw out the current criminal code laws. The next piece of chicanery involved changing the law. Remember, judges are supposed to be applying the law and interpreting the law, not changing the law. But what we have here is judges who apparently want to be legislators, or think that they are legislators, and have changed it to suit themselves. But the next step was to find that the laws against being assisted to kill yourself or agreeing to kill yourself are overbroad. Now, overbreadth is a slippery and elastic concept, but basically means that you shouldn't ban more things than you need to. Or more accurately, that a law shouldn't ban more things than the legislators, the Parliament, wanted to ban when they wrote the law. According to the judges, the existing law was intended to ban only vulnerable people from being enabled to throw away their lives. Instead, say the judges, the law's overbroad effect is to stop all enablers who want to facilitate any person, vulnerable or not, to end their life. The judges claim to distinguish vulnerable people, who are presumably anyone whose suicide they would not approve of, from non-vulnerable people, presumably anyone whose suicide they would endorse. According to the judges, anyone who thought our law existed to protect human life in general, or to prevent suicide, was misinformed. The court declared that the objective of our law was merely to provide vulnerable persons from being induced to commit suicide in a moment of weakness. The court did not like the way our law also applied overbroadly to people who some doctor could somehow designate as not vulnerable, or people that some doctor could somehow know was not being induced by anything in their environment to want to die, and some doctor could somehow know was not in a state of weakness. In the real world, faced with a request for assisted suicide, it's hard to know what's going on at home. Being unsupported to go on living can take many different forms. I think I'd like to take a look at the case of Victorino Noval. And this happened in California a couple of years ago. Even before they passed their recent assisted suicide legislation, which was signed into effect by Governor Brown just a week or two ago. And so here we have, even without the encouragement of a kind of an assisted suicide mentality, we had Victorino Noval. Here was a guy in his 70s. He was living his life, driving his car, had a lot of money. He had about $60 million, and he was making several $1 million a year from real estate and other things. And he had a couple of daughters, and he had a son. And he had the misfortune of suddenly acquiring quite a significant severe pneumonia. Now, Victorino was not on his last legs. As I say, he was a fully functional businessman who was mobile and doing his own thing, but he had the very earliest stages of Parkinson's disease, nothing more than that. It was such a severe pneumonia that he was placed on a respirator, on a ventilator. And this ventilator was able to give his lungs some support, and he was given antibiotics, and he began to recover. But as he began to recover, one of his daughters went to the doctors who were involved and said, "My father wouldn't want to be like this. My father would not want this. I have the power of attorney. You must turn off the ventilator." And so the doctors turned off the ventilator, but Victorino didn't die. And in fact, to potentially stop him from being short of breath, they gave him escalating doses of morphine until finally he did die. And if they had looked at the power of attorney and specified that Victorino's son was supposed to be of equal authority in the power of attorney as the daughter, but the daughter had told the doctors that they need not consult the son because he was a hopeless drug addict and could not be trusted. So after Victorino died, his son came to the hospital and found out what had happened, and was able to show the doctors that he wasn't anything like a hopeless drug addict. And in fact, with further investigation, discovered that the daughters were quite eager for their inheritance. And in fact, that the social worker who had coordinated the turning off of the ventilator was romantically involved with one of the daughters. So the whole thing sounds like a badly written soap opera, but this is real life. This is the sort of thing that can go on. I was trying to sleep in one Saturday morning, about a year ago, when at 7:15 my cell phone rang. And my cell number is actually on our Euthanasia Prevention Coalition website, so I have no excuse. I couldn't be annoyed if someone was phoning me in. In fact, very few people do. And as I was very sleepy, so I just sort of propped the phone on my ear, and I was sort of dozing while this person talked into my ear. Someone named Shelley, and she was talking something about Uncle Matt. What about Uncle Matt? And this is probably none of these people would think that something's happened in hospital and they mistake an ordinary hospital care for an attempt at murder on their loved one. And I thought, my only job here is going to be to calm this person down and explain that there's nothing really irregular that's happened to Uncle Matt. This is just normal medical care. But the more I listened, the more I realized that there was something rather odd about this story. Uncle Matt was 81, and he'd been out hunting with his buddies near Chilliwack, near Hope, BC actually, and he'd started to have a stroke. They'd finished their day of hunting, and they were in the truck, and one side of his body started to go a bit weak. And he said, "Take me home, I don't want to go to the hospital." So they started to drive towards home. And then it got worse. So he ended up in hospital in Chilliwack, and they transferred him to Surrey Memorial Hospital. And so there he was at Surrey Memorial Hospital. And the young woman on the phone was actually his niece, Shelley. Uncle Matt had been a bit of a rough character. He was a bit of a disciplinarian, and he hadn't gotten along well with his kids, in particular his daughter, who had been addicted to drugs, and he had a falling out. He had a son who was cognitively disabled and was in a nursing home. His wife was a person of very mild and meek personality and had no say. And the daughter, in fact, was declared as his power of attorney. And so when my contact, Shelley, arrived to visit her Uncle Matt after being out of town for a week, this was now 3 weeks into his stroke. She found that his feeding tube had been pulled out, and in fact he received no food or water for a couple of days, and that there was a sign over top of his bed saying nothing by mouth. He wasn't being allowed to eat. But he was able to say to her, "Hungry," and he was also able to say, "Thirsty." And he was able to tell his hunting buddies that he wanted to live, because some of them said, "You want to live?" Yes. He was having trouble speaking, but he was expressing himself. And so at this 7:15 on a Saturday morning, I thought, there is something going on here. There is something to this story. This isn't my average story. What's going on? You don't pull out a feeding tube 3 weeks into a stroke. If the person is able to communicate, it could take longer to reacquire their swallowing and so forth. So I said, "Well, what happened after you found Uncle Matt with the feeding tube pulled out?" Well, on the Wednesday, she went to her cousin, Matt's daughter. She said, "What have you done with Uncle Matt? Why is his feeding tube out?" And as closely as I can recall her saying what her cousin's words, Uncle Matt's daughter's words were, well, I've been tallying things up, and he wasn't a very nice man. So, Uncle Matt, of course, had several $1 million worth of real estate. I don't have to tell you that. So on Thursday, the next day, Shelley and her cousin, or actually her cousin, another cousin's husband, kidnapped Uncle Matt, threw him in a Vancouver taxi, which is one of these tall taxis out of room for a wheelchair, and they drove him down to Vancouver General Hospital. And they showed up at triage there at 10th and Laurel in Vancouver, and they rolled him in, and the nurse said, well, who's this? What's going on? You know, we brought him over because he's you know, you've got to put an IV in, you've got to give him some fluid. And according to Shelley, he was able to say to the nurse, thirsty. The nurse wasn't having any of that. These people weren't, a few phone calls determined that they weren't the powers of attorney. He was packed into an ambulance and sent back to Surrey Memorial, and they were never allowed near him. Okay, so now then Friday went by and Saturday went by, and Shelley scoured the internet wondering what to do, and I guess early Saturday morning she found my phone number at the Euthanasia Prevention Coalition, might as well phone the guy. So I thought, this just doesn't sound right. So by noon, we had assembled, I grabbed a lawyer that I know who's a good litigator, and by noon we had assembled in a boardroom downtown Vancouver, and we had a circle of these fairly rough-cut hunting buddies, and a niece and a nephew and a niece's husband, and they were all sitting there listening and very much intimidated by the very well-dressed lawyer and his two assistants. But they repeated the story, and it was more or less as Shelley had said, as far as they could see. And so at that point, I thought, this is my job probably is done. I can put these people together, and the lawyer got an emergency hearing before a judge, which you can do at any time. You know, there's always a judgment call. You can have an emergency application for a court order on many different topics at any time. And by 6 p.m., they had a court order instructing Surrey Memorial Hospital to put down a feeding tube and rehydrate this man until his wishes could be determined. And so that was served on Surrey Memorial Hospital and on the RCMP in Surrey. And then silence. Now, no one who had an interest in Matt's continued existence was able to get near him, and the hospital administration wasn't responding to requests for information. And Sunday afternoon came, and I phoned and said, what's going on? And later on Sunday, I learned that Matt had died on Saturday afternoon. And so, I would just like to say that, unfortunately, we live in a world where on the ground, it is hard to know what's going on at home. You shouldn't have to live in a world where you're looking over your shoulder at your grandchild or your child and wondering, what's our relationship like? What's it going to be like when I really go? Margaret Cottle was a palliative care physician in Vancouver who was speaking at the conference in Montreal, which we were at until this morning, was working in an emergency room in Halifax when an elderly bachelor was brought in, and he was brought in by a niece and a nephew. He was quite ill with pneumonia, and the niece and the nephew, presumably his heirs, told Margaret and told the others involved, don't work too hard on him, He doesn't want a lot of intervention. He's not that kind of a guy. Just don't push too hard to make him better. All he needed was hydration, a little bit of antibiotic. He walked out 1 week later. So, this is the world we live in. So there you go. Vulnerable people. How do you find vulnerable people? How do you decide that some people are vulnerable, some people aren't vulnerable? It just looks to me like the judges decided to claim that the law was only about vulnerability and not about preventing suicide. And this assumption was used to rig their legal argument in order to throw out the law, in other words, to do what they felt like doing. More mischief arises through the court's bizarre concept of security of the person. The trouble here actually started 22 years ago when Sue Rodriguez wanted to be dealt. Sue and Gloria and Kay, what's going on here? The vast majority of victims of assisted suicide and euthanasia are women. You know, Kevorkian's early victim, the first victim was a woman, and his early victims were predominantly women. And when you look at the activists who get involved, it's really quite astounding how many of them are women. And there's a bit of a pattern if you go probing. An interesting proportion, not by no means all, are divorced women. They're unsupported women. The women somehow have had to be strong and on their own, but it is really quite curious that these are women who in many cases are throwing away years of their lives. So what is it about this woman thing? I'd love some speculation about that. So when Sue Rodriguez wanted to be killed 22 years ago, the Supreme Court of the day unwisely conceded that the law impinged on her security of the person, her Section 7 security of the person, by delaying ending her suffering through death. The Rodriguez court conceded that the law interfered with her security of the person, but that it did so for higher reasons, and therefore that the law imposed reasonable limits on her security of the person, which can be demonstrably justified in a free and democratic society. And such limits are explicitly allowed by Section 1 of the Charter. That's the wording, justified in a free and democratic society. So in other words, the court back in 1992 was able to say, yeah, we're infringing on our security of the person, but it's actually for a good reason that's justifiable in a democracy, which is basically public safety and the protection of the vulnerable and so forth. But the Carter court seized on this unwise concession and added that the law also restricted the suicide seekers' control over their bodily integrity. This is perverse. A sensible reading of the phrase life, liberty, and security of the person has everything to do with protecting the individual from unjust loss of life or loss of bodily function, invasively imposed by an abusive government, and nothing to do with invasive impositions on your body by a disease. In the case of the disabled or depressed person who is the client for assisted suicide or euthanasia, bodily and mental integrity are threatened by disease. This is not within the power of a judge to change. To suggest that bodily disintegration through death, that is, the removal of the person from existence, will enhance security of the person is a category mistake. The opportunity to have nothing happen to you because the government is restrained from touching you is not in the same logical category as the opportunity to have nothing happen to you because you are dead. Section 7 is being abused. Really, the only valid claim that the judges have on Section 7 is its promise of liberty. For it is, of course, a matter of liberty for an individual to decree that a lethal pile of pills or a lethal hypodermic syringe be provided to him or her by the state. Whether that is a liberty which should be overruled for reasons of higher reasons of public safety or whatever reason then becomes another question. So while I am criticizing what I see as the judicial abuse of Section 7, I might as well point out the arbitrariness of providing assisted suicide only in response to the fear of future loss of the power to specify your time of death, your exact time of death. What about the subjective suffering involved in not being able to access pastimes like the procuring of a favorite recreational drug? Would the anticipation of a future loss of access to the drug because of progressive disability mean that any laws hampering your access to that drug were contributing to your decision to end your life sooner than if the state promised to provide you with that drug as you became less capable of fetching it for yourself? Would that mean that any laws hampering your access to the drug were depriving you of life under Section 7? If this specious reasoning is accepted and continues to be accepted, would the state not become hostage to the claims of any suicidal person who could blame existing legislation for their motivation to destroy themselves earlier rather than die later of natural causes? Should the Charter be used to force the state to bow to those who utter threats of self-destruction? The concept of a life interest under Section 7, you'll hear lawyers talking about life interests and things like that. Lawyers have an interesting way of speaking their own language, but the concept of a life interest should be distinct from whether the life is wanted by the citizen in the moment. It is the state's duty to avoid killing its citizens, not to inquire about how their day is going. But as I say, I will leave that all to the legal scholars. As you're sitting here, you're hopefully absorbing the absurdity, the sort of Alice in Wonderland character, the Mad Hatter's Tea-Party character of the legal scene that unfolds inside the Carter judgment. But you also may be wondering, what should we do? What can we do next? One response, suggested by a lawyer named John Sycamore from ARPA, the Association for Reform Political Action, who are a great bunch of very creative thinkers, would be to reform the wording in the criminal code to make it clear that Canadians want to protect life in general and to prevent all suicides in general. That would answer the charge of overbreadth and could potentially be used to overturn Carter. But we would need a government willing to pass such a clarification. Others have suggested the notwithstanding clause, that is the part of our charter which allows a legislature to say, we hear what you're saying, Supreme Court, but we're just not having it. And in fact, if we're not having it now and for the next 5 years, and we'll review it in 5 years, that is vanishingly unlikely to happen. So really our job can be seen as harm reduction. I come from a city where we have Insight, which is where you can go with your heroin addiction and have a clean, quiet, safe space to inject your drugs and access to a counselor and have someone there asking you if it's time to go and try some methadone. And that whole concept is called harm reduction, which is what we do when we can't eliminate the underlying social evil like drug abuse. So in this case, the social evil is our Supreme Court's judgment, and so our challenge is to minimize the harm coming from it. So harm reduction would start, as far as I can see, with insisting on honesty and transparency in the use of an assisted suicide law, to try to minimize assisted suicide and euthanasia, and minimize the mission creep, which would endanger psychiatric patients and children and mentally disabled older people who can't express themselves. The attack on honesty and transparency has already begun with the plan announced by Quebec in their Bill 52 to falsify the immediate cause of death on the death certificate to hide the fact of assisted suicide and euthanasia. The excuse for this dishonesty is that it spares the family awkward questions. But of course, the effect of the dishonesty is to hide the new practices from scrutiny. The mission creep has already begun with the proposal in Quebec that children and dementia sufferers should be the next to be included in their euthanasia law. I was astounded at how quickly after their law was passed, I think it was the next day, that one of the architects of their law was speculating that really we just had to get on now with helping people with dementia and children be included in their law. I thought, that almost shows a kind of a charming innocence about the enormity of what the person's talking about. I'd like to think that they just didn't get what they were saying, not that they were arrogant monsters immediately refuting the sort of limited conditions under which the law was supposed to apply when they were working to get it passed. So that's a really important point to pause on. These laws have been promoted based on the idea that they will only apply to people in horrible pain who are actually in the last stages of dying. And Joe Arvey, who's the brilliant constitutional lawyer who won the Carter case first at the trial court level in Vancouver and then at the Supreme Court when it was appealed to the Supreme Court, he has been quoted accurately as saying that for some people are going to die in horrible pain. They're going to die, they're going to be in horrible pain. And that's what this law is going to be all about. That's what this change in the law requires to address. And so that's what most reasonable people thought it was all about. But that's actually not what the proponents of assisted suicide and euthanasia are motivated by. That's not their end game. Because I heard Joe Arvey give a speech, in an ironic twist, at a hospital for disabled children. And I went up to him afterwards and I introduced myself and we chatted for a while. And I said, Joe, what's really got you going on this? What motivates you to be involved in this condition? He said, well, I had to watch my mother with Alzheimer's disease, curled up in a fetal position for 3 or 4 years, and I couldn't help but wonder, is there a better way? So here's someone who couldn't possibly give informed consent to euthanasia, and it's her situation that's motivating her son to change the law. So you think, okay, well that was just, maybe I'm just misquoting Joe Arvey. He doesn't really want to see this generalized to people like his mother, even though he claims that that's what got him interested in the whole thing. Well, how about Jocelyn Downey? Jocelyn Downey is a law professor from Dalhousie who has said quite unguardedly that there's no principled reason why assisted suicide and euthanasia should be withheld from people who aren't actually dying. She put that in print a couple of times, once in the Royal Society's rigged panel on this topic. It was simply stacked with people who were going to come to a preordained conclusion that we should do assisted suicide and euthanasia. And she also, it was also, I noticed the same phrase in a speech that she gave once, and I was given a transcript of it. So no principled reason why we should not euthanize or arrange assisted suicide for people who aren't even dying, but are simply dissatisfied with their existence. And of course, this is what we see happening in the Netherlands. This is what we see happening in Belgium, where someone unhappy with their sex change operation was euthanized. That's a very, very sad story. Here was Nancy Berhelst, who was, by the time she was 12 years old, she'd been born into a family where there were older brothers. And when she came along, her mother told her she wanted a boy. And Nancy was given the message that she was a second-class citizen. Her brothers were given far more attention. When she was 12, she began to be sexually abused by her brothers. And she, perhaps not unsurprisingly, began to form the idea that she would rather be a boy. And so by the time she was an adult, she eventually underwent the sex change medication and the surgery. And she was unhappy with the results of the surgery that attempted to simulate male genitalia, and her unhappiness spilled over into their euthanasia system, and she was killed. Now, I just can't imagine a more serious business than the state adding the abuse of murder onto her already troubled life. It is an outrage, and yet it just passed as a curiosity in the popular press. Similarly, the twins who had been born with a defect of their hearing and had always lived together and began to lose their vision, and at the age of 45 were euthanized in Belgium. This just goes on and on, that the use of euthanasia on psychiatric patients now, people who are depressed, anorexic, bereaved, is now something that's starting to spread in these places. And I wish I was making these things up. They're just so sad. So, harm reduction. If we can strive to craft the law in a way that respects the Supreme Court's claim to want rigor and stringency in the application of this newly defined situation. If we can frame the law in a way in which assisted suicide is an exception to a reason for prosecution in the criminal code, then that's where harm reduction will start. If we can frame the law in a way in which an application for a court order is required for each state-sanctioned suicide or state-sanctioned killing, then we can restrain these evil practices to some degree if we insist on the kind of transparency. And I'm not saying to identify these people publicly. All of this information can be de-identified, but presented so that the public knows who's being killed and why they're being killed and how they're being killed. And I think that that sort of transparency is the only check we're going to have on the inevitable mission creep, the spread of these things to situations which the legislators will simply say, oh my goodness, we could not have foreseen this, but of course they should be able to foresee it. What could we do besides harm reduction? We should now strive to maintain a safe space inside our healthcare system. Both a safe space in terms of institutions being allowed to not have anything to do with these practices, and individuals being allowed to dissociate themselves completely from these practices. Now, it is very encouraging to hear that the palliative care centers, these 21 or 29 in Quebec, have declared themselves to be safe spaces. No one wants to have a loved one in a hospital somewhere where you can't be at the bedside, and where a suicide-minded doctor or nurse could be attending your loved one. And who knows what could be communicated, who knows what seeds could be planted there. No one wants that. And there are many, many people who don't want to be in a hospital where assisted suicide and euthanasia add to the attitude hazards that are already present in hospitals. Hospitals, I'm not trying to be sensationalistic here, but they're just not very safe places unless you're over a certain threshold of illness. If you're really sick, it's safer to be in the hospital than outside the hospital. But otherwise, for most people, there's a point where it's safer to be out of a hospital. And many of the hazards in hospitals come from... Let's get that under control. You know, things break down all the time. You know, things go wrong. Like, you didn't watch your phone to tell us something. You know it is. And hospitals are just full of ordinary people. Some of them having a good day and some of them having a bad day. And some of the biggest hazards in hospitals are attitudinal. Someone was just telling me how upset they were when they went to look after their mother in hospital. This was just recently, and I hear these stories very, very frequently. And they somehow got a glimpse of the chart and had a do not resuscitate on it. This guy's mom is in the earliest stages of Alzheimer's disease. She's early enough that although she's carrying on a social conversation, as he put it to me, her processing power was slow. And she must have been asked by some physician. He challenged the physician. He said, oh, I had a conversation with her. And she said, yeah, I didn't want that. Well, who knows what kind of a conversation? When sometimes I'm phoned from the ward and people say, why is this DNR order on this patient of yours? And when I'm feeling cranky, I usually say, well, you know, if they arrest, I think you really need to practice running the code. And if I'm not feeling cranky, I just say, well, you know, they feel better knowing that you'll try to help them out if they appear to be dying. Because how do we know they're not choking on a piece of broccoli or something, you know? So attitude hazards in hospitals. There's a large number of people who don't want to have to go to a hospital that shares space with people who would kill directly, or people who would hand a pile of cetyl barbitol or something over to someone in order that they kill themselves. And I think that we have to really hold on to this idea of a safe space, because to imagine that just because the Supreme Court has decided that some people, under some circumstances, should have a death that is endorsed and approved by the state, should not mean that every citizen is from henceforth all over Canada in every healthcare institution obliged to live under the shadow of that practice and under the kind of mental attitudes that is going to breed. So I think it's the rights of a very large number of people. I'm not claiming it's the majority. I don't think it matters. The rights of a very large number of people are about to be violated by what I call a winner-takes-all mentality among the people who won the Supreme Court. They're on an attack now. And in fact, they don't only want their assisted suicide and euthanasia to be available universally throughout every part of the healthcare system. And by the way, the only reason that the centers of palliative care in Quebec were able to say we're not part of it is that they're explicitly excluded in Bill 52 from having to be part of it after fierce complaint during the process of drafting the bill. They were lucky to be excluded in that way. Like, I'm sure the government is saying, oh, well, it's just a bunch of hospices, as we would call them. And so, you know, it doesn't really matter because the real action is going to happen in hospitals. That's where people are going to be sitting. Instead of sending them to one of these uncooperative hospices, we can just euthanize them in hospital. So, I really think that at least now there can be shrieks of dismay and outright anger coming from everybody saying, I don't want to have to go into a hospital where these practices are going on. You cannot railroad every institution to provide these. There are over 100 denominational health facilities, for instance, in Canada, and part of the Denominational Health Alliance. And many of these are Catholic hospitals, and if they are forced to provide these on their premises, I don't want to be sensationalistic, but it could spell the end of Catholic healthcare. And there are 16 faith groups represented in the BC Alliance of Denominational Healthcare Facilities. We're not just talking about some narrow sectarian thing here. We're talking about a whole bunch of people who have no interest in these practices crossing their threshold and who need to be protected. And along with protecting the institutions comes protecting the individual healthcare professionals. And it's really must be emphasized here that we're not talking about conscience rights as being some private whim that we have because we can't get over some little foible we have about some squeamishness we have about young people, and we want to just go, oh my goodness, I keep myself pure. Don't really care what happens to that person who's suffering. I just must keep myself pure. We really must guard against conscience being portrayed that way. And I can tell you that an organized attempt to define conscience protection out of existence is underway right now. And that is to displace conscience with ethical distress. And I didn't understand how methodical our opponents were until a year ago when I went to a talk at Women's Hospital in Vancouver, Bill, ethical distress in medicine. I thought, ethical distress, that's right up my alley. They're going to be talking about people whose consciences are truly distressed by what they're having to do. Oh no. Ethical distress is defined as your distress at finding out that your client is not getting the services that he or she wants out of the healthcare system. That is your distress at finding out that access is somehow impeded for your patient to something that they want. On one of their PowerPoint slides, they had a list of things that ethical distress could be, these access problems. At the bottom, what ethical distress is not? And the second item was conscientious objection. One of the puzzled members of the audience put up their hand and said, but like conscientious objection, if it's your conscience and you're being asked to do something that's isn't that like ethically distressing? And the two, Dorothy Shaw, who's one of the higher placed people in Women's Hospital, and the hospital ethicist, whose name I can't remember, simply couldn't explain it. You know, they talked around it, but they couldn't explain it. They couldn't explain to this person why an obvious ethical distress, like having their conscience trampled on, was not an ethical distress. And so you can see that maybe they sort of regrouped after the session and said, well, nice try, but we've got to think of some more techniques here. But you can see what they're up to. The idea is to define the only moral issue in healthcare is how people that want something get to it. Not, is it good for them? Is it good for the rest of society? Is it good for the people that have to provide it to them? Could it have a deleterious effect in some way? There's no question of deleterious effect because that doesn't enter the moral analysis. The word is want, what you want. And so with that kind of thing going on, I'm going to skip a little bit because I'm running on as I always do. How much time do we have? A bit more?
5 lines.
Okay.
And then questions.
And then questions, okay. So, want. So, forgive me for starting to read again, but I'm going to If an unbalanced focus on autonomy, because that's what we're talking about, right? Autonomy is just a fancy way of saying what you want, continues to captivate our judges, more and more system access issues will need to be solved for more and more contentious practices. It is long past time to decouple access to newly tolerated practices from the conscience rights of those who feel ethically bound to stay away from complicity in those practices. We cannot fully imagine what technology and the chaos of human nature will come up with next. We can guess at new reproductive and genetic technologies. We can guess at new experiments in living, as John Stuart Mill so innocently put it in 1859. What we can be certain of is that citizens will not be unanimous in their approval of each innovation as it arises. Yet legal access will be declared necessary for many of these innovations. It is not wise or necessary that rights of professional judgment and conscience be sacrificed on every such occasion. It should be the responsibility of society at large to arrange access to newly declared rights or services which that society at large has endorsed as acceptable behavior. Responsibilities of access must not be presumed to fall on the currently existing practitioners in some related field of knowledge. In the case of assisted suicide, which is technically easy to provide, existing practitioners of a related but separate field called medical care must not be presumed to be obliged to provide the only route of access. Assisted suicide and euthanasia can be, and in fact are, provided in Holland by mobile teams. No hospital space is required, no special medical knowledge is required. Truly, anyone of normal or near normal intelligence could perform these deeds. Any self-declared multicultural and pluralistic society which cannot solve procedural access issues without trampling the rights of objectors to those procedures is simply derelict in its duty to the equality of its citizens. Such a society is being manipulated by power and is failing to control its bullies. Such people are always amongst us, itching to suppress the opinions and freedoms of others. In a wisely governed society, they will not be allowed to run things. So I think I might just wrap up there to give some time for questions. I had one final reflection as I was preparing this talk. Euthanasia advocates insist their supporters simply feel better and fear less, knowing that assisted suicide and euthanasia are ready and waiting. We must find a less dangerous comfort than the constant offer of suicide on demand to help them feel better and fear less. Public safety is the issue here. We don't leave loaded handguns left lying around. Somehow, somewhere, somebody's going to get hurt. We don't say, well, some people are comforted by having a loaded handgun around. And so I think that we're going to hear that advocated as well. And I think, again, this is just an example of the imbalance that's happened in the rhetoric. So you have people saying, yeah, well, we know a few people may die, but think about people that will just feel better. You know? So, what a topic. Well, I could go on and on and on, but I don't want to do that. I actually want to invite some questions and address some individual issues.